The Fourth Amendment, it protects us against unreasonable searches and seizures. But is it unreasonable to not just search someone, but take their DNA, even if they're just suspects in a crime, then use that info to solve another crime? Or is your DNA pretty much just a modern fingerprint? The Supreme Court, they decided today, there wasn't unanimity, but they came up with a decision.
Yeah, the ruling this week, Rich, is essentially that it's just like a fingerprint. The court ruling on a case where a suspect in one case had his DNA taken and tested and then used to solve an unrelated crime. The ruling raises questions about how something very personal, your genetic material, is treated by law enforcement, and it split the court in an unusual way. The majority included the moderate Anthony Kennedy, conservatives Roberts, Thomas, and Alito, and the usually liberal Stephen Breyer. The dissenting group was even more unusual. Antonin Scalia, the ultra-conservative, teaming up with the court's three most consistent liberals, Ginsburg, Sotomayor, and Kagan. And in the majority opinion, Justice Kennedy likened police use of DNA to that of fingerprints, calling it both legitimate and reasonable. But Justice Scalia disagreed, voicing his concerns in person, reading his dissent from the bench. He said, quote, "Make no mistake about it, because of today's decision, your DNA can be taken and entered into a national database if you are ever arrested, rightly or wrongly, and for whatever reason." Rich?
And Mark, you had the confluence of the progressives who are worried about basically liberty and rights here in the criminal justice system, and then the conservatives who are worried about government overreach, all melded together. What did you think of the decision? What do you explain why, for example, Justice Alito says the most important criminal case or case that's come before them regarding criminal law in the last 20 years? Why was it so important?
I don't think that's true. I think the GPS case, probably from last term, is the most important case in criminal procedure that's come before them in 20 years. And in fact, I don't think the practical effect of the decision is going to be that great, because as Scalia points out in his dissenting opinion, everybody agrees that you can take DNA samples from people who have been convicted of crimes. So this incrementally expands the pool of people from whom DNA can be taken to include arrestees for felonies.
But do this, where somebody gets pulled over for being a suspect in drunk driving.
Right. Well, that's not what this decision says. That's that last sentence that was quoted from Scalia. That's what he predicts will happen in the next case when that comes before the court.
What it leads to is the definition that different people can have, or foreseeable, or what is significant, or serious crimes here. That's a different interpretation depending on the person. My point is, if one person says, well, you know what, somebody getting pulled over for a DUI, even if they prove to not fail the standards, we're going to still keep the DNA on record, versus now you're innocent until proven guilty. They're making that leap beforehand.
Well, the statute also provides, the one in this case, and 26 states have it and the feds have it, that if you're acquitted of the crime, the sample is supposed to be destroyed, or not convicted of the crime. The problem is, before you get acquitted, they can use the sample to match you up to something else. Well, take the case in Maryland,
because in many ways it's kind of applicable. Some guy gets King, right? He gets accused of a crime, but apparently the search wasn't right or something else. They have his DNA sample on file, though. And then all of a sudden they match it up with an unsolved rape, and they got the guy. Now, the court said in Maryland, well, wait a minute, it wasn't a legal search, so everything's tainted from that, in effect. Supreme Court, they said not so fast. You do the crime, if we have your record, you're still guilty.
I think that King actually, and Scalia points out in his dissent, I think that King, the defendant in the case, was actually convicted of the assault, and he says that they could have taken the DNA afterward. So the real evil of this is going to be the use of the DNA from people who are ultimately acquitted or exonerated. Now, the question is how far you go with it. Anybody could make a slippery slope argument, and Scalia's argument is well taken. But you have to your point, you have to go back to earlier in the term where the court held that you can't just take blood from somebody who's arrested for a DWI without a warrant. You can't just do that as a matter of course. So when you're dealing with the Fourth Amendment, it's always highly context dependent, and it's very largely contingent on the facts of each case. I practice mainly in federal court. This is done routinely, the taking of the DNA in federal cases. The hard case, as you suggest, is what's a serious crime. Generally, a serious crime means a felony. The majority opinion in this case is very wishy-washy as to what constitutes a serious crime, and hence you have these alarmist predictions by Scalia in the dissent, and that may or may not come to pass.
Well, let me bring in the table on this, because I saw this really fascinating thing about since 9/11, when it comes to privacy rights, how much has changed, and how much we haven't even debated. We just kind of accepted and it moved forward. And I bring in Basis Michael, who's joined our panel right now, looking resplendent in green, by the way. Yeah, very much.
The green side of the table over there.
Do you absolutely? They color coordinated. Isn't that adorable?
Rex Ryan.
Yeah, exactly. don't be bringing it down like that. Let a man dream.
Though I'm a Cowboy
Do
fan,
you
but that's
think
also-
this is just, this is part of advancements in technologies? This is just, don't fight it, let's go with it? Or have we given up our privacy and personal rights in small and large ways here, and we never even had a debate about it in this country?
Of course, we've given it up, and we did. We had a little bit of a debate around the Patriot Act, but I think what's happened, 9/11 changed everything, quite frankly, and the Boston bombings changed everything. We've been on this. You talk about a slippery slope. It's a hugely slippery slope, but we've been on this slope for quite some time, at least the last 10 to 12 years, and I think Americans are and should be concerned about how we classify things, definitions, how we classify what is a serious crime. But the reality is that even if we don't get those full explanations, there is a good chunk of the American population that will be okay with this if an argument can be made that this is about your safety and security.
But Richard, I'm confused here. Maybe you can explain it, or maybe the council can explain it.
Probably Mark.
If law enforcement takes your fingerprint, right, that stays whether you're convicted. You can get it back if you're acquitted, but it's the same thing as if they're taking DNA. I mean, so the same way the DNA will always be around is the same way a fingerprint will always be around.
That's the weak point in the objections to this, but the retort to that is that the constitutionality of fingerprinting under the Fourth Amendment has never been addressed by the Supreme Court. It's something that they just say has always been done, so we're used to it and we can live with it. That's one thing. The second thing is that fingerprinting is truly used to identify somebody. If they print you as pedigree or booking information when you go into the jail, for example, that stays with you throughout your duration in the BOP. This is used purely for crime solving.
I know I got to hit a time here, guys. I just have one question, which has to do. A lot of the arguments for the last 5 years have been, and always will be, whenever there's a Democrat in the White House, about government overreach, too big government, intrusion on your personal lives and privacy. And I'll give Scalia credit, at least on this. He's always consistent about this point.
About the Fourth Amendment, he's very
But to me, it's a different issue, which is, look at some of the fights we're having about Washington. Too big of an intrusion in your lives. But yet when it comes to giving up the most personal thing to you, your rights to privacy, for example, national security letters. If people knew what could happen with national security letters, I would hope the majority of people would be freaked out. It's as if there's collective amnesia or selective amnesia on the part of conservatives that, oh, it's okay, go ahead and do whatever you want to me, but oh, wait a minute here. Somebody's going for, to the IRS here for, some charitable designation. That's different. That's big government. I mean, aren't we fighting a selective fight here?
Well, no, but big government has many different connotations, as you're alluding to. First thing is big bad government that spends all the money and takes all the taxes, spends all the money. That's one big government. What you're talking about is intrusion, which I think when you talk about 9/11 and what's
how about guns?
done.
They're going to kick your doors down and take your guns away. That's my constitutionally protected right.
But
well, I also have a right to privacy here, but you know what? That's kind of like, never mind.
Well, but the challenge here, though, is they're taking something from somebody and keeping record of who they are and what they can do to match it up to something that may have happened in the past
or
in the future. Well, that's a very different scenario, because that's a name and name only. My concern about the DNA, as I was talking off air before, was really one of, once they have that in the system, what else can they do with it? They're only using some of the bands of the DNA,
right.
But at some point, as technology improves, where will it go from here? The internet was only simple before for email and some other junk on the internet. Now it's used every day in our pockets. So you don't know where it's going to go from here, which is much different, I think, in the big government where you're talking about and trying to put all these together.
I got to hit a break here, but real quickly, tell people other cases the High Court's going to hear and probably will decide this session that they ought to keep an eye on.
Well, we're going to be done by the end of June, and obviously the two same-sex marriage cases are pending, and the immigration case, those are the three that most people are looking out for. There is another very, very interesting substantive criminal law case, but I won't bore your audience with that.
It was affirmative action one too, right?
The affirmative action, which
University
was
of Michigan,
argued,
right?
the first case argued in the term, still not decided yet.
Okay, we take a quick break, but when we come back, This is a debate here that was interesting. It's come out on Long Island, in effect. Should the names of Johns in a prostitution sting be published in the paper? Be interesting. Yeah. Be interesting some of the reaction here on why they think that's good or bad policy. We'll have that right after this.